Thank you to everybody who came on time, but it looks like there's some traffic problems on the east side, and we're just going to start a few minutes late. We're just going to watch the binders and see. Okay, thank you.
Okay.
My name is Helen Bernstein. I'm Counsel Program Development at the Law Society. I want to welcome everybody to today's program, Border Issues for Employees and Executives. We hope you take some time to fill in the great course evaluation because it helps us with future programming. We want you to know that we are videotaping this program in order to distribute it in video format. And we'd also like to thank the chair of the program, Howard Greenberg, a prominent member of the Immigration Bar and a specialist in immigration, and our entire faculty for all their efforts in making this program come together. I know you're in for a really interesting day, and I'm going to turn the podium over to Howard.
Before we start actually with the program, I traditionally take a look at the binder with you. So let's do that for a moment just to see how much padding's here, how much is real. There's two articles that came afterwards. One of them was entitled I think Tips for Processing. I don't have it with me. It was handed out in the handouts. That was meant for Robin's panel, which is tab 1. And the second is Yusra's on where to file consulate versus port of entry. And you should insert that as well before it gets lost. The program, when I initially designed this program, this is probably one of the shortest programs we've ever planned for. I think the planning line was about 5 weeks. I only expected maybe 40, 45 members of the bar to sign up. Small interim program till the big one comes in November, December. And I think we're breaking 100 now. There's people coming on the highway and whatnot, but there's another 50 to come in. And I think that goes to the issue of how prominent the border is becoming in a daily practice. I think that the old days of immigration being focused on permanent resident applications from processing all around the world has really shifted somewhat, and it's important for practitioners who want to understand where this is going in terms of your practice down the line to understand that the border is becoming even more critical for processing purposes, and it's really important for you as a practitioner to know what's going to happen to your client at the border if you choose border processing in place of consulate processing worldwide. In order to give this program some direction, rather than have a free-for-all, which I hope it doesn't turn into, we devised a fact situation, which you'll see under the tab Fact Situation. The fact situation is not very abstract in the sense that when I drafted it up, this is exactly what multinational corporations say to me in my first telephone call. So I just reflected their comments in a fact situation to allow our faculty to wrap their mind around the kind of issues that we as lawyers are asked about in going to Canada and the United States. I thought it was important in a program like this to talk about the flip side. You've been reading a lot more in the newspaper lately about the U.S. entry issues, registration, fingerprinting, etc. It's important to hear who's subject to it and who's not, and what you're going to tell your clients before they actually get in their car or get to the airport. That's an important part of this program. That's the afternoon. The morning was to get a little insight into some Canadian issues, both in substantive in terms of HRDC and processing, which Robin's going to come up and talk about, and border with Stephen Green and Yusra in terms of things that could happen to you that you don't expect when you get off a plane and think things are fine. Speaking of things are fine, to my right is the representative of the Assistant Deputy Minister who was contacted and invited, and she said no. She couldn't make it. Things are going on in Ottawa, and we've made it a couple of steps down the chain. And we were happy to get Pierre Gaulin, who I hope I pronounced your name correctly, who tells me that he was a line officer in 1972. Probably with Chantal in 1972, I would think. And so we've got somebody who's well experienced from the Ontario regional level to give us a little bit of insight as to what the current thinking is about the Canadian border and what direction we're going in from a legislative and policy point of view, to the extent that they're communicating that to you. And then from that point on, we'll move from our keynote speaker over to some substantive discussion as to how you move back and forth Canada-U.S. border.
Thank you, Howard, and good morning, ladies and gentlemen. And I am pleased to be here with you this morning to talk about everyone's favorite topic, immigration. And as Howard said, I've been around since 1972, and immigration is a topic that captivates many of us, and many of us in immigration are lifers, because it's such an interesting topic. And I think that I did start before Chantal, a few years ahead of her. Anyways, as Howard had indicated, Lise Ricard was invited, but she couldn't make it. She had other commitments that kept her in Ottawa, but she does send her greetings and best wishes. Here in Ontario region, I think we've developed a very good working relationship with the Ontario Bar Association Immigration Section. Many of you know that we hold meetings on a regular basis, and a few years ago, about 2 years ago, we decided to develop a port of entry subcommittee, and it brings to the table myself as well as some of my staff, and as well as members of the Ontario Bar Association. David Garson is the co-chair of this subcommittee. And we take the opportunity to discuss many border issues that legal practitioners encounter. And I think we're making great headway in resolving issues and addressing issues. We do bring some of our managers, frontline managers, to the table so that they can hear the concerns directly from lawyers. So I think that it's been a very good initiative, and we are working as well on other initiatives, that pilot projects that hopefully will make the border a little bit more friendly for some of your clients who come across the border looking for employment authorization. The border is a very important part of our program. This is where it's the gateway to Canada, whether it be the airport or a land border. And I mean, it's part of our everyday life in terms of the work that we do. But I think as well, you know, because of the world events, the border is becoming commonplace in terms of what people, the general public, discuss. And obviously September 11th and the threat of war with Iraq is bringing many changes at our borders in terms of how we do our business. I think in the last few years we've really seen a lot of cooperation between Canada Immigration, CCRA, and our American counterparts. And I think the citizens of North America, not only of Canada, but North America, are looking for us to protect them from terrorist activities. So the expectations there are extremely high, and you know, and that we will live up to that task. And the Immigration and Refugee Protection Act that was introduced last June has given us some tools to deal with some of the issues and the expectations that we have. We have been very much involved in the Border Vision Initiative. There have been ongoing meetings with the U.S. authorities over the last 3 to 4 years, and you know, the end product is not quite clear yet, But we've been discussing a variety of issues where there could be more cooperation, and we will certainly see some changes over the years. And actually, we are seeing some new programs being introduced, and I'll be talking about those briefly in a minute. Canada has also adopted a multiple border strategy with the idea that only legitimate travelers will arrive at our air and land borders, and hopefully this strategy is a way to help us deal with issues of fraudulent documents and people smuggling activities. The multiple border strategy starts overseas with our visa officers as well as our interdiction officers who work very closely with foreign and Canadian air carriers to train their staff in methods for detecting fraudulent document. The new permanent resident card that everyone has heard about provides permanent residents of Canada with a much more secure identification document, and this will prevent abuse of the old less secure immigrant records, that infamous form IMM 1000, which will no longer be valid as an identity document for travel purposes. Now, sometimes I think that in the business of port of entry, we are a little bit schizophrenic. On the one hand, we have a lot of pressure on us to promote free trade and promote the passage of goods and people without too much hindrance through our borders, while at the same time we have this very important mandate to protect the safety of Canadians. But it is, while all of this is going on, we cannot lose sight of the fact that there's an awful lot of business going on between Canada and the U.S., and we are very, very dependent on that trade with our partners to ensure that our economy remains buoyant, but also to make sure that we meet all of our labor force requirements. And we take very seriously the fact that we have an important part to play in the economy of Canada. And certainly in a province like Ontario, where it's the industrial heartland, we are very cognizant of the fact that we have an important role to keep that economy going. We've been working, as I said before, with our U.S. partners and CCRA to develop new programs and develop ways and means to get people and goods across the border quickly. You've no doubt heard about Nexus. This was the first four-agency program, and I think it started in Sarnia now about 2-3 years ago. And it is now being expanded to other ports of entry across Canada. This was actually the first initiative under the Border Vision Initiative that I referred to earlier. Now, these alternate inspection programs allow cardholders to pass through designated booths at the PIL without requirement for a formal examination. These individuals have been pre-cleared, and therefore they are considered to be low-risk traffic and should be able to pass through the border without too much hindrance. There is still some monitoring that takes place occasionally. Now, a Nexus card, however, does not negate the need to hold an employment authorization if one is required for work in Canada. We're looking into the future to the expansion of the Nexus program to airports, and Nexus Air will be introduced at major airports in the U.S. Once we have operating procedures and all agreements signed. We also have other programs such as the Commercial Driver Registration Program and the Fast and Secure Trade Program being implemented at our border points. And these are programs designed specifically for truck drivers to allow these truck drivers to pass through the border without having to stop. So that's for the truck driver as well as the contents of the truck. So as you can see in this just-in-time economy, These programs are very useful to not only the trucking industry, but also the manufacturing industry in many parts of Canada, and especially in Ontario. As we all know, the economic forces are more than a north-south issue, and as Canada competes in the global economy, we must remain competitive in terms of the products and services we create and sell around the world. And in order to compete, we have and to remain on the leading edge, we have to have a competitive workforce that is highly skilled and motivated. And we have to find ways to replace an aging workforce, and we must also find ways to continue to expand our current labor base. Many industries right now are faced with the issue of baby boomers who will be retiring soon, and they must be replaced. And this is really becoming a major issue in terms of succession management for many industries, whether it be private or public. And consequently, we'll have to rely very much so on immigration to replace those who are moving on, retiring, and also to fill new jobs that are being created on an ongoing basis. It was interesting that from the most recent census information that came out about a month or so ago, that in a dozen or fewer years, immigration will account for all net labor force growth in Canada. So in other words, if we want the labor force to grow in Canada, we will depend on immigration. There are not enough people right now in Canada to take on that challenge, that we will need to bring more immigrants so that our labor force grows. In the last speech from the throne, it was stated that immigration is truly a solution for the Canada that we want. It's clear that we're facing skill shortages in a range of occupations, and we can play a very helpful role in that. And our goal as a department is to ensure that Canada continues to attract the immigrants it needs in order to fill the existing shortages. And as the global economy expands, so does the competition from other countries to attract the best and the brightest. So we're not the only ones out there trying to attract skilled workers. Skilled workers are out there, and they're looking at all the countries, and they're looking at the most desirable country to come and show their skills. Consequently, we're in a real race for this. I was meeting last week with some representatives from Australia, and they're certainly involved in that race as well. So it's not only Canada we just can't sit back and say, oh, they're going to come to us. They're out there shopping their skills around. So we have to be proactive and make sure that we attract and retain people who have skills in high demand. So we feel that we now have a law and a series of new regulations that will permit Canada to attract more skilled workers, tradespeople, and highly educated people. And this is what we need to build Canada. And the speech from the throne also recognized that the best way for Canada to mature is to maintain its openness, and we continue to be open to immigrants from the four corners of the world. Those people who will be attracted here are those who will feel that Canada offers them an opportunity to be creative and to show their skills to the best, to their advantage. The Government of Canada and CIC, through the Innovative Agenda, wants to make sure that Canadians have not only the skills and knowledge required by the labor market, but also the ability to adapt to a global market for human resources. The innovation strategy in part proposes higher levels of language training for some newcomers to facilitate their integration, job-related initiatives with employers to give newcomers critical work experience, better labor market information and job search assistance, and promotion of the skills of immigrants, immigrants bring to Canada, so that more people can appreciate their real contribution. Some of these initiatives were recognized in the most recent budget speech, and we will see some new programs being developed to promote some of the innovative, some of the strategies that I've talked about. The CIC is committed to working with partners, especially the provinces and the territories, business and academia, in order that we can move this innovative agenda ahead. The government is also committed to fast-tracking skilled workers into Canada when jobs are waiting for them, and position Canada as a destination of choice by more aggressively selecting and recruiting through embassies abroad. The selection grid focuses on adaptable skills and attributes such as education, knowledge of official languages, and capacity to adapt, which are essential qualities for success in today's labor market. At the same time, Canada's system gives us options to bring in other skilled workers who meet specific needs under the provincial nominee program. We've already started working on some of these goals. The minister recently met with the provincial and territorial ministers on immigration matters. It was a very fruitful meeting. They talked about shaping a partnership to develop a fair, consistent, and transparent processes to assess and recognize foreign qualifications as quickly as possible. If we need doctors, nurses, and engineers, we have to find a process to speed things along. We want to ensure that when people come here with their families to help build this nation, they do not have to wait years and years before taking their rightful place and using their skills. Foreign credential recognition is a very real challenge in the labor market. This is a critical area for Canada to move forward on. Many newcomers to Canada face almost impossible barriers in having their credentials recognized. Unable to practice in their field of expertise, they must take lower-paying, lower-skilled positions. This can often have a detrimental effect on their adaptation to Canada and can lead to many systemic social problems. Canada has a gold mine of skilled workers waiting for a chance to contribute significantly to their communities. The immigrants who enter our workforce will help us improve the overall skills of Canadians, and they will help our economy adjust to the retirement of baby boomers. But Canada will not continue to be a destination of choice if we do not find ways to use their talents, skills, and knowledge more effectively. We need quick and fair assessments so newcomers can benefit from their skills. We need to work closely with accreditation bodies and professional associations. We must also make sure that Canadians are well served by an assessment process we put into play. For example, Canadians would want to know that a foreign-trained doctor can serve them as well as one trained at an accredited Canadian university. We are also talking about things like better promotion abroad, fast-tracking these applications of those with job offers, and improving processes involving students and temporary foreign workers. The department is looking into providing newcomers with better access to labor market information, and we continue to work with our federal government partners such as HRDC on those issues. We've already updated our website to include up-to-date information and links to relevant sites, and this will help to demonstrate how Canada can be a destination of choice for skilled workers both before and after they arrive. The department is considering how information resources can be developed to help Canada's employers access the skills and assets that immigrants bring to Canada. The Immigration and Refugee Protection Act gives us tools to make the system work for Canadians and immigrants alike. The government and the department is working with partners to achieve these ends, and at the same time we will continue to work with countries and international organizations that are interested in migration issues. This is especially important in program areas of the immigration program where cooperation is critical to deal with challenges which lie ahead. I am confident that our immigration system will help to foster innovation and contribute to Canada's growth and prosperity for the 21st century. Thank you for your attention. I hope you will have a productive seminar today. And I know that you have some interesting guests later on There will be someone from my office who's quite well versed in issues, border issues, employment issues, and I know that some of you may know Nadine Heaslip from HRDC, who will be able to answer some specific questions and address some specific issues that you might have. So it's been my pleasure to participate today. And unfortunately, I have other commitments, so I won't be able to stay the rest of the day, but thank you very much.
Thank you for coming. I wonder if I can. I wonder if I could just poke around with a question or two before you run off. So let's talk about Nexus here. I just want to understand if I heard you correctly. Are Canadian immigration facilities being located in U.S. airport facilities like pre-clearance?
No. What Nexus is a program developed in partnership with USINS, U.S. Customs, CCRA, and CIC. And there is an enrollment process where a person interested in participating enrolls. We do all the background checks, and once the background checks are passed, we issue a card. There would be a Nexus booth at an airport, and now at a port of entry it's on the pill line, where the card is swiped. It has some biometrics in the card that identifies the passenger and allows the passenger through. And it will be a very similar process at the airports, although those processes have not yet been defined. But it will be probably very useful for frequent travelers who can go through an airport very quickly.
And I presume it would be available to foreign nationals here on a work permit as well as
Would be
permanent
available
residents.
to American and Canadian applicants. Yeah.
Okay. The second question I was going to ask you about was the good news in the budget that $7 million had been allocated to fast tracking, and I guess you just don't know where to spend the money first.
Well, in terms of the dollars announced in the budget, we're not. It hasn't filtered down in terms of what it means for programs, but I'm sure that it's probably related to a lot of these alternate inspection systems that seem to be shaping the way the border will look in the years to come. So we're kind of in a transition period with 1 foot in the past and 1 foot in the future.
Okay, my last question is, in the next 6 months, what would you predict or see changes that would occur at, for example, Pearson? I was thinking about you last night as I was standing in the most horrendous lineup.
Well, hopefully Nexus will be one way to speed passengers through, but when you have, what happens often at Pearson is that you have the way overseas flights are scheduled. They're always scheduled to come in at within a certain period of time, which means that those lineups are there. They are a reality. And we are working all the time to streamline, but
So we're at the early stages of introduction of new technology or processes that are going to wisp workers through.
Well, hopefully that Nexus, CAN-PASS programs, these types of things will allow passengers, travelers to move through the border in a more efficient way. Yes.
Okay. Sure, jump in.
Mm-hmm. Well, I think that David Garson, as the OBA representative on the subcommittee, makes minutes of our committee meetings available to legal practitioners.
And a short email to him, and then you'd have the last minutes.
I would suggest that you propose them through David. Yeah.
Okay. Thank you.
Oh, I think there's one question there. Yeah, it's mostly, right now, it's mostly commuters, people who work either in Canada or the U.S. who use the border quite a bit. For them, it's a way and means to get across faster, although I hear that in the last few weeks, because of the orange alert in the U.S., there were long lineups of trucks and so on. So, but you know, on any given day when traffic is not hindered by special inspections, it permits people to get across the border much faster.
Thank you.
Thank you
for your time. That was the official view. Robin? Robin Seligman and Nadine Heaslip are going to join us to continue this discussion into a more nuts and bolts format. I gave you a fact situation which is fairly generic. It wouldn't take you too long to appreciate that virtually all multinational corporations or employers you might be acting for in Canada are interested in you getting the work permit quickly, inexpensively, and not causing any legal liabilities for their HR departments who are worried that you may have overturned the wrong stone. And this panel is designed to speak about the issue of work permits and access to Canada strategically. Robin Seligman should be well known to everyone in this room, especially if you have a computer and you're on the CBA's, OBA, I should say, CBA and OBA's internet. She's highly active in most major issues that are ongoing. And I thought Nadine would be a wonderful complement to Robin because usually when you fight your way through the HRDC bureaucracy to Ontario Region to make some sense of a decision, you end up at Nadine's door, who speaks quite frankly and sensibly about what HRDC is trying to do and what the solution could be to your problem. You might want to get her business card before you go and save yourself an hour of telephone calling. So I thought maybe you'd like to make some introductory comments, and then maybe we could poke around a bit as to the kind of things that lawyers should be watching for.
Sure. What I plan on doing is just doing a general overview, and then we'll go to what Nadine has said. You know, if all else fails, go to HRDC. So those aren't my words, but we'll go to the fact situation in HRDC. And in terms of the IRPA, so I'll go back actually to my materials. I presented a lot of stuff from the actual HRDC website, the form that you'd have to complete sometimes, the list of a bunch of HRDC offices across Canada. For some reason in Ontario, it only has, I believe, the Toronto office, and it's missing a bunch of other offices. I'm not sure why. And I've also provided the printout of exemptions, people who do not need work permits, and then a list of people that if they need work permits, they don't need confirmation from HRDC. And then what I considered just the first 30 pages of the foreign worker manual, which if you haven't printed it off and read it out, you really must, because it's a very good summary. And in there, there you show a chart. There's a transition between what the old regulations were and what the new regulations are, if you hadn't had a chance to look at that. And some very practical information about the exemptions. And even, I think probably the only written material other than the IRPA regulations on what HRDC's role is, because my understanding is there's no HRDC manual, and it does talk about neutral effect and neutral or positive effect and sort of what HRDC's role is. So in terms of, I think a good starting place is Regulation 2, and I've also, it's referred to in the manuals. You look at what does work mean? And I think that's always a good starting point to determine, is the person actually performing work? And in terms of the materials, when you have a chance after, you go to Regulation 2, it gives you the definition of work, and of page 6 of the materials, it talks about situations which would be work and then situations which wouldn't necessarily be work. And basically things that you're entering the labor market when you enter the labor market are generally determined to be work or defined to be work. But then I think it's interesting in the manuals that immigration has said what kind of activities we do not consider to be work. And I think if you haven't read it over, you might be surprised, because it talks about if a relative comes in and wants to help a relative in their business on a short-term basis, if they're helping build something or do something for a family business. So I think it's worthwhile taking a look at that, because a lot of situations that are unpaid and short-term and dealing with relatives, what people might consider they're doing something wrong, they're not necessarily doing something wrong. So I would take a look at that. Also, one of the things to consider is determine whether the person that's entering, if they're staying for more than 6 months, require medicals. And if so, then they're not going to be able to apply at a port of entry. And then I would look at the no work permit required situations under Regulation 186 and 187. And that talks about all the people that don't need, the people who do not need work permits at all. And you talk about your business visitors, and you get into trainers, and you get into religious personnel and foreign representatives, and they're listed in there. I'm just going to be specific today about business visitors. And I think what's interesting is under IRPA, which is new, is that they talk about after-sales service as business visitors. And it looks like a lot of what's in NAFTA is paralleled in the manuals for other people who are not American citizens or Mexicans. So after-sales services in there to deal with people that are coming in to do installations, and pretty much parallels NAFTA. So that's good to keep in mind if people are coming in under a contract and are not from a country that needs a visa, they could come under that provision and actually do installation and some hands-on stuff. Then the next sort of category you get into is work permits required but exempt from HRDC confirmation. And they're covered under Regulations 204 to 208. And in that area, you're dealing with international agreements such as NAFTA, GATS, and again, there's a list in there of all the different international agreements. So people need a work permit, but they don't need to go to HRDC. And then there's a whole listing of other categories where you get into people that are going to create significant benefits, which is Regulation 205, and it's referred to now as C10. And you get into, within significant benefits, it's further subdivided into entrepreneurs and self-employed individuals, people that are coming here to set up a business. In that section, under C11, when it came out, it's been amended since then. It didn't cover self-employed people. But what you have to look for under entrepreneur and self-employed, if the person has a Canadian partner, it specifically exempts them from fitting into that exemption. So if you, which is unfortunate, I don't think it's a good thing, and I would hope that that eventually will be amended, because it's not practical. If someone has a Canadian partner, they're going to have to go to HRDC to validate their own position for a company that they own if they want to come in. And in many situations, it's just inappropriate. And I've actually had opinions from HRDC saying that we will not validate or confirm self-employed people. So you sort of get into a catch-22 where HRDC won't get involved because the person owns the business. And, but in terms of visa offices and ports of entry, they won't necessarily issue a work permit under an exemption. So something to keep in mind in that. That's C11. And then you get into the intercompany transfer provisions under C12. And what's changed in that area is that the person now has to be employed for 1 year with the company, and that was not the case. And again, that's sort of similar to that is similar to what's under NAFTA. It has to be 1 year in the past 3 years. And they have the same categories: senior managers and executives and people with specialized knowledge. And in that regard, the occupations it appears that the manuals and the non-NAFTA people the sections may be a little bit more restrictive, because they specifically talk about the people have to fit into the top NOC category. And they also talk about the area of specialized knowledge seems to be a little bit different as well in terms of how it's worded, and it looks like it's more restrictive in the sections that are dealing with just straight intercompany transferees not covered by NAFTA. And so I think we'll pick up on that later. Maybe we can get into that. But in terms of timing, in terms of intercompany transferees, if people are senior executives and managers, initially they can get a 3-year start and they can go up to 7 years extensions under NAFTA at 7 years. So what I don't think is clear in the manuals is how long they'll extend for people that are non-NAFTA. But NAFTA people can extend up to 7 for the sort of the senior positions. For specialized knowledge, the manuals are quite clear. They'll only give non-NAFTA people 3 years maximum, and initially 1 year. Under NAFTA, a person could get 5 years for specialized knowledge. So things to keep in mind when processing. And then the last section, which we'll get into, is HRDC, which before we get there, you have to determine, I guess, the timing of the application, which is dealt with in the regulations and the manuals. But in terms of, you could apply before the port of entry, which is section 197 of the regulations, on entry, which is 198, and I'll talk about that a little bit more. It's in the manuals at page 16, and in that regard, which will tie us into our fact situation, all nationals or permanent residents of the United States and residents of Saint Pierre, et cetera, Miquelon and Greenland can apply at the port of entry, and that would apply to HRDC confirmation situations or other situations, so the exemptions. Those people can apply at the port of entry. So people that don't need visitors visas or temporary resident visas can also apply at the port of entry, but only if it's not an HRDC situation. So those are situations to sort of assess whether you want to do it at the port of entry or not. After entry, you would look at Regulation 199, which talks about people that are in Canada that also can apply for work permits, and there's a broad range of people in that category as well. So then we get to sort of your place of last resort, which I in my personal experience, has been getting a little bit better over the years. Well, quite a bit better over the years to deal with, more flexible. And I think IRPA has brought in a new dimension in terms of neutral effect and positive effect. And that's covered by regulations 200 to 203, and it's also in the materials as well. And it's listed a bunch of factors that have to be taken into consideration. For example, labor conditions, availability of other people, specialization, all that type of thing. But there's no weighing of factors, which I think is something where we have to be involved and be creative. But there's no, it talks about and, they use and, the term and, so it's not or, so it looks like a combination of a bunch of things. So you have to weigh all those factors and then combine it with the manuals, which talk about, the section of the manuals is page 17, which talks about other things that you have to take into consideration, and that seems to be the only written material and direction for HRDC. So I think at that point we'll let Nadine maybe talk a little bit about HRDC's role.
Hopefully this is on. Great. Thanks, Robin. And I guess she's said it all. So I looked at Howard and thought maybe I should go for a coffee. Looking at the fact situation that you have, if someone was to send me something perhaps with an employer's name on it and the information here, I would say I wouldn't have enough to know where to start. The information as to the purpose of the visit in Canada and what they're doing is very, very, very vague. As Robin mentioned earlier, there are options now available under IRPA that were not there before, both through some of the visitor categories as well as some of the HRDC confirmation exempt categories. One of the first things that I would do if someone called me and provided me with such limited information would be to ask first off, what is the job description of the individual that's arriving? And as you know, there are some intra-company options now that are available, and some of the manager categories, etc., are most specific to executives, managers, and specialized knowledge workers. And someone or a corporation's definition of a manager might be another corporation's definition of a first-level supervisor or a shift supervisor, and not always a manager. That personally is where I would start as far as the job descriptions, the purpose of the visit. Could be visitor, could be intercompany, could require validation. Once again, it's not specific. They're not talking duration. They're not talking the reporting structure. There is a reference made to someone coming in, supervision of hiring and termination of excess staff. What does that mean? Supervision of. Is this a supervisor coming to supervise supervisors? Is this a senior manager coming to perhaps direct a manager as to a specific outcome? Will the hiring, will that be incremental hiring of who's being terminated? Will this be perhaps a project that will result in more jobs for Canadians? It's very, very vague, Howard, and I guess perhaps you could provide us with a little more direction or specific questions. Or
Okay. If I can comment on the presentation so far, let's just recap so we can understand the structure. You're handling on behalf of a corporation multiple entries to Canada of different types of people. So you're getting different types of telephone calls every day. Some of the people, so you're going to get them to range from, will you assist us in getting our vice president or our new president into Canada, who's going on the Canadian payroll, has got a desk and an administrative staff and an office, all the way through to what do you think we should do about John Smith, who's coming up to Toronto to go to the Westin Hotel for a convention or a meeting. What's the evaluation of his situation? Do we need to do anything but give him a letter? And to put this discussion into that framework, this new legislation is actually quite clear in terms of helping you give that advice. It first of all gives you a definition of work, which was never there before. Number two, it gives you a definition of business visitor, which was never there before. And so what you're left with is a definition which basically says, unless you're coming into Canada and remaining on your home payroll, not challenging a Canadian in the labor market, not listed in one of the exemptions which Robin has alluded to, for which you can come in and continue to work, well, you can work even though you would need a work permit, for example, training for up to 5 days. You're going to need a work permit, and that's a critical first step that you have to undertake as a lawyer. And why do you have to do that? Well, if you advise your client to just prepare a letter and send along the worker, and you have not made an evaluation as to whether work is occurring, and that person comes in as a business visitor and fools the port of entry officer by not giving a complete explanation in a fast line interview, that person is barred for a work permit for 6 months from the date they start working without having a work permit. So the problem with this system, and the reason why you have to be more vigilant as a lawyer than you had to in the previous legislation, I don't know if I could say you should be more ethical than you were, but more vigilant certainly, is because the lacks in the system, the failure to ask all the questions in a big pill line at the port of entry can work against you. It's just not that your client got through the system and that's great. At the end of the day, if your client works, the prohibition against getting a work permit is 6 months and now mandatory, not like the old provision which allowed the visa officer or port of entry officer to still issue a new employment authorization. This one is devastating. And what if it was a senior vice president in the company you were doing this for who couldn't go to his or her job for 6 months? The repercussions would come right back to you in advising. Number two is how you structure that presentation has a lot to do with if you are being creative and you're trying to capture it as a business visit, you don't have to worry about a work document. You don't have to go visit Nadine with the long explanation. And you have been too creative in it and have not fairly taken the principles that Robin's discussed into consideration. You may have a misrepresentation situation, which could have all sorts of issues as to that your vice president is barred for Canada for 2 years, and these misrepresentation provisions trail the paperwork from the HR manager, that poor person who was just signing the letter you told them to sign, all the way through to anybody who contributed to that process, right through to the lawyer's office who was guiding it how the letter should be prepared. Because any of those events which had anything to do with the administration of the act, that's the language in the new act, catches you. And some poor HR person who happens to be a permanent resident who misrepresents may be subject to deportation, even though they didn't intend to overtly twist the system. If they didn't, if they understood that their comments were not fair or may have been misleading in any way, there could be an issue. And that's why that preliminary decision as to whether or not your individual requires a work permit or not is a very important first step that Robin's taken in that analysis. And when you get through the issue of am I exempted, and then the next step, which is if I'm not exempted because it is work, is there anything in the act that lets me off the hook, any special provision? And then once you finish with, I read through the manual and the act and I can't see how I'm out of this. So is there a fast work permit that can be done at the port of entry where I can prepare the letter and get this president in tomorrow afternoon at 4 o'clock and look really competent and on the ball? You're looking at NAFTA and GATS to see if you've got the 1 year and to meet the transferee requirements, or GATS, which is a little bit more stringent in terms of how that specialized knowledge is looked at. Or the NAFTA, which Asher will talk about this afternoon in terms of professions you might qualify. Once you get through that exercise and you find, oh my God, the president hasn't worked for a year with the transfer company down in Anaheim, and therefore I don't have an intercorporate transfer, and he doesn't fall clearly within a management consultant or an accountant, so I can't use one of the professional designations under NAFTA. So I'm left at the end of the day with, what's this HRDC thing all about? And so this HRDC thing, if you look at the regulations, actually started injecting a strong HRDC role inside the immigration environment. In the old days, it was an opinion of a national employment officer. I think it was 4 words in the whole legislation. Now, all of a sudden, they put their arms around you and they include you in the process, and they say that the visa officers have to have regard to your opinions. And now what opinions do they ask you to give? They ask you to provide a letter which says whether that particular individual's employment, and this is where you're back, you're supposed to tell me if I'm wrong, will provide a neutral or positive economic benefit to the economy?
I don't believe the word is economy, if I'm not mistaken. I'm sure you
Okay,
have
I
it
tried
in
to
front
trick
of you.
you.
Yes.
It just says neutral positive effect.
Okay,
Effect.
and then they give you a list of factors.
Correct, and the factors included under IRPA are certainly broader than they were before. In the past, although in Ontario, I guess it might be said that we didn't adhere as closely as other provinces to our role under the old Act, was truly to only assess the wages, working conditions, and the recruitment of Canadians in every decision that we put forth to immigration. Under the new Act, there are a number of factors that can be now considered. One of them, as always, would be the recruitment of Canadians. But our role under the new Act also is to look at the benefits to the Canadian labour market, that being the retention of jobs, the creation of jobs, the transfer of skills. So in the case where you might have a senior executive that, after careful review and assessment, it was determined that no, they couldn't enter as a business visitor and also couldn't enter under any of the exempt categories, and an HRDC confirmation is required. At that point, the submission would be based on a written submission signed either by the employer or yourselves as a third party with written authority, and submitted to HRDC in Toronto or wherever. It's important to remember this is not an on-the-spot decision and could take up to 15 working days to have your reply on a submission. And most definitely, if there's been no recruitment, under the new act, HRDC certainly does have the other factors now to consider. And I'm quite sure if you have a senior VP that would be coming in perhaps to open a plant in Cambridge or to introduce a new product line, etc., that I can safely say that any time it's been clearly demonstrated that an employer needs a foreign worker versus wants a foreign worker, that I've not yet come across a case in my many years where they have not received the positive opinion of HRDC.
What's a neutral opinion?
It's not an adverse effect.
Okay.
And unfortunately, there has not been a formal definition that has been provided by our national headquarters.
So just to be clear on that last point, I have no manual to have recourse to understand how you apply your policy. Other than the Immigration Act and the regulations, there's nothing put out by your department that I can give back to you in my submission to explain what I meant by...
At this time, it's not available. However, it's my understanding that all of this information will soon be posted on the National HRDC website.
Okay. This is subject to what that says when it comes out. This is by opening up the opinion to the factors which are on page 1-3 of my paper, A to F. You could theoretically have transfer of knowledge, which is one of our favorites. You could have like transfer of knowledge. Somebody obviously knows something, and somebody else wants his or her knowledge. You could have that transfer of knowledge, and Nadine, you just jump in here if you think I'm wrong. I wouldn't want to misinform. You could transfer that knowledge even if that knowledge was already in Canada. If in an organization, if you needed that knowledge because it would help you be more efficient, it would help you be more productive, it would help you be more competitive, you could say, I need John Smith's understanding of that software because that software is critical to how we run our accounting system, even though somebody out in British Columbia still might be able to run that accounting system?
I think it would be fair to say that it has to be clearly
Is it labor market?
documented. We're always looking at the labor market, Howard, and whether you, and often, and I think that it does indeed get back to the job description. If you're saying to me that I have a secretary perhaps that could use an internal reporting computer system and she happens to be in another country and we'd like her here because she can use it and it's something that requires little training. I certainly don't know if the HRDC would provide you with a positive opinion.
At that extreme, I probably agree with you, but when you get into somebody who's got some more substantive contribution, that labor market issue might give away a bit to...
And I certainly think it's important to clearly document the seniority of the individual, if that's the case, or if it's a manager, that it is perhaps a mid to upper level manager.
I was going to also just mention it in terms of the actual sections to refer to. It's section 200 of the regulations, and it actually says neutral positive economic effect on the labor market in Canada. So I'm wrong. And then in terms of the factors, it's section 203, sub 3 of the IRPA, which specifically sets out what you need to know. So those two sections together with the manual is all you have. And it's not that clear.
No, and I guess we have to get back to HRDC's role, being an opinion to HR or to immigration on the impact on the labor market, not the impact to the geographic area, but on the labor market in the geographic area, on the labor market in the local office that is making the decision, and what might perhaps render a positive opinion in one city in Canada, it might not necessarily be a positive opinion in another city in Canada.
I was also just going to go back to Howard's example of a president that has not worked for the company being moved to Canada, and I actually had that situation come up last week, and sort of was at a time that company called and said we're moving him on Sunday, and it was I think Wednesday or Thursday, and under the old act, I think most of you would know that we could probably maybe rely on significant benefits. This person's going to come in, they're running a company, they're getting paid over 200,000 Canadian dollars. You'd think that would be a benefit to the company. They would be willing to pay someone that much money, and you can't use it. All right, I would check out very carefully Regulation 205, significant benefits, intercompany. Well, it's not intercompany, but significant benefit sections, C10. And they are very, very tough. That section's clearly been tightened up, and if you have one of those situations, I think you're going to be stuck with HRDC. So you absolutely have to go that route.
Can I comment on that last point? That's really interesting. When you think about your arsenal of weapons that you have to succeed in getting this work permit, we know that the whole Nadine discussions there on the table with the lag periods associated with it, which you may or may not want to comment on. But if you're going to the port of entry on Monday, you're probably not going with Nadine's labor market opinion. It's going to, you're not the only one in the pile, and it works its way through, and the system hasn't been designed yet to turn those out efficiently, and maybe the minister will give you some of the immigration money to do that.
Nice.
But in the interim, they're not they really are a place of last resort. If you had another mechanism for getting someone in and you started fooling around with these letters with HRDC, your client would have good reason to question your strategy. But then Robin points out, in the old days, we used to kind of flip around these ambiguous exemptions to try to get people in, and you had, one of them was that significant benefit. Did you reproduce?
Yes, it's at page 26 now of the manuals, which is in the materials, and it's C10, Regulation 205.
There's considerable discussion ongoing now with the economic section in Ottawa over these exemptions, and I discussed them in my paper, but...
Well, it actually says, given the focus of the HRDC confirmation is principally on labor market, officers should be particularly reluctant to apply C10 to situations where the only consideration is economic.
And that's actually the operative line. Because I can't figure out a significant benefit that doesn't have an economic implication. So when I called up, I said, okay, so what's this about anyway? So we played this kind of immigration ping pong where you roll around for about a half an hour on the phone, and you hang up and you realize what they're just trying to do is they're trying to avoid, they want you to go to Nadine, and they're trying to close your other avenues without getting rid of the exemption. And so...
I've seen it used, though, many times, Howard.
I'm sorry?
I've seen C10.
Oh, I'm not saying that they're getting what they want. I mean, in the field, what you then, the exercise, which I guess Yusra will discuss in the next panel, is how to find a user-friendly visa office with people who are going to say, look, this is how I interpret that line, and I'll interpret more generously than the X line. There's certain places you won't go to make that pitch, and there's certain places you will go. And maybe you'll extract that from Yusra, if she's generous this morning, to tell you who's giving significant benefit these days.
But then you're going to get into Regulation 11, which we hear is going to be implemented soon, and the person will likely it's going to apply to temporary status, family class, and skilled worker, and you'll likely have to pull that person will be pulled in for an interview. So something to take into consideration as well.
So you might be walking them down a fast track for consulate and then get invited in, except if they otherwise qualify at the port of entry, they can make their pitch to a port of entry officer, and we're going to, I guess, hear a little bit about that when Paul Dowden comes as to how receptive they are to a significant benefit standing at the airport with people all crowded in line behind you, trying to make the pitch and how you're the brains behind the operation. That might be an interesting one when you're sitting in your office waiting for that answer to come through.
And if I might say, I don't think C10 was ever intended to circumvent HRDC either. So I think that's
right.
That's one of the key points, is the HRDC if HRDC does indeed have a process to address that client's needs, then.
Interesting, I used to get a letter from you in the old days to say this was not a labor market issue. And then I take that labor market issue back to the visa office and say, now I want significant benefit because you sent me to her. She tells me that she's not going to do it because she doesn't think it's within her mandate. And so then they keep saying, we'll go back to her and tell her. And so you end up with, everybody's got a letter written on this with no work permit. There's another interesting point, Robin, which I'll bring up. It's great that you reproduce this in the materials. It's also an issue in my issue paper. That is that the intercorporate transfer provisions have changed rather remarkably. What they tried to do was incorporate the NAFTA aspect of it into the Canadian law. And by doing that, they used the 1-year requirement, which is NAFTA, we also know senior executives and managers were allowed in under the old E15. They're incorporated in this, only they now have to have 1 year, not 1 day. And then they also incorporated this concept of specialized knowledge, which you've seen in NAFTA, so now it's worldwide. So, to the best that I can understand, what they've tried to do was harmonize the E15, the NAFTA, and the GATS into a test, more or less, that's one test for everybody. They haven't done this very well. If you look at page 30 of the Foreign Worker Manual that Robin reproduced under specialized knowledge workers, in particular in the box in the middle, which tries to define what specialized knowledge is, which is going to be 85% of your intercorporate, no, but everyone understands that the president's and senior manager or executive, and you don't have issues. When you start climbing down that tree and you get into the programmer that understands how the software works a certain way, he's going to use it in the Canadian operation, that's when you're into specialized knowledge. And we suggested to the department that they didn't get it right. They didn't get this right. If you look at the third bullet point, a person who possesses specialized knowledge would be in a position critical to the well-being of the enterprise. Well, how many people in an organization are critical to the well-being of the enterprise? And so what they did is they moved that standard up higher than what the NAFTA standard is. If any of you are involved in transfers to the United States, you would know that it's a subjective test. If that individual you're sending to the United States has specialized or proprietary knowledge, that person can qualify for an L1B without any difficulty. And there's no suggestion in the U.S. language whatsoever they have to be critical to the U.S. operation in any way. So they've imported standards in the Canadian, which we can't find in the NAFTA, and moved up the standard for NAFTA, GATS, and this new intercorporate provision beyond, I think, what they could do. So that was an ongoing discussion with them, which has resulted in a draft discussion paper about what amendments they were going to make. And I don't think that the paper ever made it into the manual, which is what I asked yesterday. Yusra, they didn't republish the manual since the first. Okay. So this is an issue. It was an issue at first with visa officers who, when you were on the phone with them, read that line back to you and asked you if he was critical before they gave you the work permit. At the port of entry, I don't think that they see that bullet point. Strategically, you might be better off to process in locations where the officers can't remember all the bullet points. You really don't want the luxury of, let me think this one through for about 2 hours. Friday afternoon at 5 o'clock for specialized knowledge is perfect for me. This policy is not correct. It doesn't properly articulate the law, and therefore I'm not suggesting to you that you're perverting the system and the administration of justice in any way by suggesting that somebody took a very, very narrow view of specialized knowledge here and really took this tool and twisted it in a way which I don't think was intended. So strategically, you're thinking about that intercorporate process, specialized knowledge process, and you can see that when you're finished with that elimination process and you can't meet the 1 year requirement, or you really think that they're going to be soft on the on making the NAFTA case for any reason, you're always Nadine's door is always open to you. And they don't charge any money. One of these anomalies in the system where everybody charges you every time you talk to them, HRGC doesn't get it yet. So they don't charge any money.
Not yet.
So you make your pitch as much as you want. It doesn't cost you.
I was going to ask if Nadine might want to expand on advertising requirements, because it's something that comes up, and I think it's probably varies from office to office. And if you can make any general comments about, or not even so general and then specific. For example, if a president was coming in, would their advertising be a requirement? And if so, do you have to go the national edition? And
Well, I think what we would hope that all our staff would be using good judgment on what would be required per the occupation of the foreign worker. There are some occupations in Ontario right now that we would expect very little advertising, although some, such as nurses, pharmacists, recently doctors, we have special programs that do exist for tool and die makers, some construction trade workers. beyond that, I think that you would look at the occupation and what would be successful for an employer. Would the employer expect to recruit a Canadian through the Globe and Mail? Would an employer expect to locate a Canadian or permanent resident through the Toronto Star, the Toronto Sun? Yes, indeed. And I can't recall whether in the new act they use the word national advertising, whereas I believe in the past it said national recruitment. Our expectation in most cases is either within the province, depending on what city or town you're dealing with, or, example, in Toronto, something that would expose that job to the GTA. Some occupations, and if there is a very clear case documented that you know that there are only 3 individuals in Canada that have the skills to fill this job vacancy, and you've contacted all 3 individuals who have the knowledge and skills to do the job, I would suggest that the employer or yourself approach the HRDC before you place any ad in the newspaper. I certainly would never like to see advertising for the sake of spending money and having a piece of paper. The focus of advertising is the recruitment focus and not the cost. So there's not a provincial or national standard.
Nadine, do you want to comment on, you raised an interesting point from jurisdiction to jurisdiction. My head office is in Vancouver, but I want the worker from my factory in Mississauga.
We would certainly be looking at the location of the actual work.
In terms of the actual application process that lawyers would undertake, the application made to the head office, HRDC, who in turn coordinates it with the Oakville, or?
Well, normally what happens is if there's only one job site and the job site happens to be in Ontario and the head office is in BC, usually the employer or third party would submit the request in Ontario. However, if there's one head office and 4 work locations across the country, then normally the submission goes into the head office. The HRDC in the head office area would then contact the other provinces to see if they would support a request for foreign workers.
That's another interesting point. If you had an validation exempt category open to you, and you had a person who was going to be employed in multiple locations, you certainly go for the exempt work permit with a remark that may be employed at employer sites throughout Canada, rather than start with HRDC, because by the time all these offices have discussed it with each other, the job's probably over.
Well, and I think it's really important that if there is an exempt category, that it be used at all times, and that HRDC not issue a confirmation for the safety net or something in the pocket. And I think that that's important to remember. You're quite right.
Although, Robin, I just want one last point on that. Not every, for getting the 10-point credit for PR, some exemptions do not offer the 10-point credit. For example, reciprocal benefit.
Yes.
So you could be a genius in finding this exemption to get your guy in on a work permit, only to find out when he goes into the immigration process he gets killed.
Yeah, I would check they're in sections 70 to 85, I believe, the regulations, and check which ones are covered. And the exemptions, for sure the ones that don't need work permits are not covered. And then you have to be specific that international agreements are covered. And so be very specific and check, because you don't want to be in a situation where they are on the work permit getting no points for arranged employment.
And therefore can't immigrate and want to know what you did a year and a half down the line, why you chose that category, rather than coming to Nadine, who would have given it to you anyway, and you would have had the points.
Yeah, very important. Another thing that I was going to mention, which is sort of a bit off topic, but that's new in terms of where you can apply. Mexicans and Americans that are in Canada on visitors' visas can apply under NAFTA from within Canada, so through the CPC, which is something that was not allowed before. So
That turnaround time's about 17 days.
Yeah.
So, case processing centers is a really good alternative if your person doesn't want to travel or can't for some reason.
Yep. I think there was a question.
Is there anything in parallel in Canadian law to start on what you have an intercompany transfer who wants to set up a business in the United States, a Canadian citizen, and wants to transfer him or herself or an employee down, but it's a new business, and
Well, just the intercompany transfer provisions. It's specifically in that chart, but I think they'll give it for 1 year for a startup. Yeah, yeah, C12 or C12.
Nadine, I'd like you to comment on refusals that we get from HRDC stating that we refuse to confirm entry-level positions, even where the training required for that position is very specialized or rare, such as first-year actuaries.
Not having the specifics, I can't comment. Normally, most, all decisions, I would hope, are certainly based on the reasons that we discussed earlier, either the recruitment of Canadians or unsuccessful recruitment of Canadians or the other labor market benefits. I'm not sure that's in the case that you're mentioning. What was the basis for the submission? I guess that would be number one. If it is certainly an occupation in Canada where there is perhaps a surplus of students or trainees, that might be the case. And I would say without the details, I certainly couldn't dare to.
But then the reason for the refusal should not be that HRDC does not confirm entry-level positions. It should be something to the effect of recruitment efforts haven't been made in Canada or haven't been demonstrated.
I can say I haven't seen a refusal myself based on the fact that the job is an entry level. So I'm sorry, I really can't comment.
What Yusra is alluding to is actually a problem that's come up on the CBA web internet amongst lawyers who are one of which was discussing an issue that the salary was considered to be too low to justify a labor market opinion. And that lawyer said, but in the facts of that case, that individual did have something to offer, but because they were being paid $34,000 and didn't have years of experience, they were eliminated from the process with a negative labor market opinion. And so there was a sense that the determination by HRDC, threshold determination, may be how much money you're being paid and how many years experience you have as an initial threshold before you get into the real consideration of the merits.
I think in most cases we would certainly be looking at what the prevailing wage rate is for the occupation. And I'll give you an example. If an employer has an occupation that they're saying, yes, indeed, I need someone with 5 years experience and a BA, etc., and then through local labor market information, we find that the wage that employer is paying is well below the norm. That often is a very clear indicator that the recruitment for a Canadian was unsuccessful because it was not a competitive wage rate. That I could see certainly happening. But the fact that I have not seen a refusal based on the fact it is specifically an entry position, unless it is something that's a low wage, there's been no recruitment, that there's no experience or prerequisites for the job, and it's truly a trainee position, maybe. I would have to see the actual case.
I would say from experience that you're looking at probably $50,000 as the minimum salary for getting HRDC validation, even in.
We found
I'm finding that to be the general situation, whether it's a policy or not. That seems to be the rule of thumb. People might want to comment on that. Faye?
I had one just last week. I was in Toronto, and it was service specialist within the car industry, and that was validated. He was being offered 45, but he has commissions, etc.
Bring them over 50, yeah.
But in fact, he had originally offered 29 with commissions and bonuses. That was too low. So total 45 would be appropriate.
I had a refusal recently that there was a list of, I guess, deficiencies. The only deficiency on the application was that this was a too low of a skilled position. Yet when I look at the criteria section 203, I don't see that because we had extensive recruitment, a complete inability to find someone to fill this position. It was a horrible, horrible, horrible job. And the owner's brother was the only one that he would say would take this job because everybody else has quit. And we had quite documented, these are the people that we hired in this position. This is the salaries. According to HRDC's salary positions, it was above the salary position.
What was the position?
A chicken catcher.
A chicken catcher?
And we truly also, you'll note that the reference is wages and working conditions, and I guess it's,
That's inherent to the job, so that you can't say this working condition is not,
Yeah.
that's not going to attract Canadians, because that's the nature of this successful business. And he needed another crew supervisor because his business was expanding. And there was no one that he could get to supervise people going out catching chickens.
and I certainly couldn't comment without seeing this.
Oh, but I can. What requirement?
Howard.
Just out of curiosity, you have to have like fast feet or big hands or.
Rubber gloves.
Another quick question, is there, I know with L1H, when you're going to the States, you can show that you never met the cap by just being an intermittent or a commuter. Is it the same thing when you're coming this way? If you're a US-based person coming up on an intercompany transferee, living and working in the United States, coming up as an executive, is it going to be the same thing once you get to the 7-year? If you can show that you've never been here on a full-time basis and maintain your residence in the United States or elsewhere, will you be exempt from that cap?
It doesn't look like there's an exemption. I think the cap is firm. Unless.
If you apply under NAFTA, NAFTA sets out. But if you're applying under the domestic, I mean the other one, I don't see, unless there's a regulation that specifies, which there isn't, like the old 5-year rule in the old days, which I could never find because there was no 5-year rule, just carried over from year to year. I don't think there would be an issue in extending it so long as you didn't make the application under NAFTA, because the treaty itself would prohibit you from going beyond the time, even though it wasn't used, even though each day wasn't used in Canada. The fact that it was issued for that duration, I think, would consume the time period in NAFTA, but not under domestic provision.
But I am correct. Like, when I deal with the Americans, they say, if you're a commuter, you're not going to hit the cap. And
Well, that's because under U.S. law, the days that you're in the United States are counted to intermittent travelers who are on H's, for example, don't use up the first 3 years if they're only there for portions of it, or else. Therefore, you can add it on at the end. Whereas Canada, our legislation doesn't define it that way, or policy.
In last June's issue of Canadian Gazette, there was a little section that said there are new provisions also allow larger employers to present a comprehensive hiring plan to HRDC to allow them to justify the non-Canadian component of their hiring plan as an element of the firm's overall human resource strategy. Is there a format that you need for this comprehensive hiring plan?
No, and I would like to just, I guess, expand on that. The new act does allow for either a one-on-one request, being you've identified the worker and the employer is now requesting that worker, or an employer to anticipate hiring a number of workers and approach the local HRDC beforehand, and at this time using the application and an attachment that would list the specific jobs that the employer would be would perhaps predict that they might have to go abroad to fill, or a sector approach, whereas we would have a number of employers from a sector approach HRDC and get approval in principle before they start their recruitment. There is, at this point, as of yesterday, not a form that's been designed or distributed. So.
You mentioned construction workers earlier.
Mm-hmm.
I'm wondering, is there a role, building trades unions and the hiring halls play a role in that labor study, in the recruitment studies? In other words, does HRDC consult with the trade union hiring halls to see if workers are available, or do trade unions have to be aware of potential working areas?
And I must say, first of all, it's not my file. Information on the construction trades initiative or agreement, that information is indeed on our website. I'll make sure I leave the website address. And it's my understanding that there was consultation with, and I can't be specific, a union in the sector as to the feasibility of entering such an agreement.
That was Ontario, right?
Yes, and it is only an Ontario agreement. It's not Canadian.
Thank you, everyone. I'm sorry, Michael.
I mean, what's the thinking now? We had a discussion 6 months ago in
Well, my personal opinion would be, and I've stated many times to our officers across the province, if the job indeed will exist for 2 or 3 years, I would suggest that you request 2 or 3 years. And I don't know where this 12-month cap may have come from in the past. It never did exist. And unfortunately, I think it's one of those rules perhaps that was definitely passed down over the years. But certainly if you have a labor market need for 2 or 3 years, ask for the 2 or 3 years. And of course, HRDC will then make their decision based on that duration of time. And we can certainly hope that CIC will then issue the document. And I understand that they will and have been issuing 3 years. Well, I would think most definitely that there's a labor market need. And if you have a job, perhaps that there's a very short training period for and a very lower or semi-skill level, and you're saying to us, I need this person to fill this labor market gap. And of course, that is the basis of the HRDC confirmation. And when will this gap stop existing? And if indeed that you're saying that I need this person and I need them for 3 years, most certainly I think that you better say why you need them for 3 years.
But most employers will tell the lawyers, the reason I want 2 years or 3 years is because this market's tight, and I know that if after 12 months go by, I'm still not going to find somebody. It's a tight market. That's why I want 3 years.
Well, then I would think that if you would have something to support that I've either had recruitment or I'm aware of the number of graduates out of Mac or Western, etc. I don't see a problem with it. I don't know if people in the room have experienced difficulties with the HRDC thing, the end of things.
One last point I thought I'd bring up before we've gone over about 15 minutes, but what if I was to suggest to you that my employer is not located in Canada? That I come to you for a labor market opinion, and my client is in Louisiana.
The employer is in Louisiana. There should be no difficulty. I know you've asked me that question because no doubt, Howard, someone has said to you that the employer must be in Canada.
This is actually a really important point, especially if you're doing, for example, software consulting, where the company is outside the Canada and the person's going in for a client site and they don't fall within the software development worker project. Your employer does not have to be a Canadian employer to qualify for HRDC labor market opinions, so long as the foreign employer controls the activities of the individual.
And unfortunately,
pays the individual.
The computer system that we input this information into has led some of our HRDC officers to believe because the computer won't take it without a postal code, perhaps we shouldn't do this. And it's very, it's a rumor. It's not at all correct. The employer can indeed be outside of Canada.
To reiterate that, I just specifically got the opposite answer from an officer a week or two ago and passed it on to my consultant company in England, that they were hiring people to place computer people with a Canadian bank or something, and we came back to them and said, well, you better get the bank to issue the offer, even though they're not really working for the bank, they're working for you.
An employer could most definitely be located outside of Canada. An employer that is making the request for HRDC confirmation can most certainly be located outside Canada and be a foreign employer with work that will be required in Canada. Was this in Ontario? Your request was it to work in Ontario? So I'm sure I'll hear from you.
Tonight.
That late?
Thank you, everyone. Thank you very much, Robin. Thank you, Nadine. Our next panel, before we take a break, will deal with why you should go to the border or why you shouldn't go to the border for your processing.
My dear friend Paul Dowden.
Is it a break now or close right now? Is it on right now?
Yes, we're going to do it right now, and then we're going to have some coffee. Do I have a resume? Can you introduce him? Do you mind doing that?
Yeah,
I don't have a resume.
I'll give it to you here.
Wow. Welcome. To my far right is Yusra Siddiquee, who works in my office and does a lot of labor market issues. Sits on the phone an awful lot with visa offices and officers and whatnot. So she's going to tell you the secrets of her trade as soon as I turn the video machine off. Paul Dowden, I have your resume, which is in the materials, is your regional program advisor at the Port of Entry Directorate. And you provide advice and guidance on foreign worker issues to immigration officers at ports of entry. You have general geographic responsibility for Niagara and St. Lawrence border crossings. So you're the person that tells them what they're doing right or wrong, I hope.
Not necessarily. I give them advice and guidance. They don't have to listen to me. Frequently they don't. Sometimes they do.
Thank you for being with us today. Okay, Yusra.
My paper was included in the pocket, and if you want to just insert it now in your binder, you can. It's Where to File, Consulate versus Port of Entry. I'm just going to go over the highlights of my paper and then turn it over to Paul, because I know we all have lots and lots of questions to ask him. How fast can our employee enter Canada? That's probably the most common question that we practitioners get asked. And most of the time, we don't really have much choice in the answer that we provide. If it's an Indian national in the United States on an H-1B who needs a temporary resident visa to enter Canada, and he'll be entering for more than 6 months, but he's been in the United States for less than 6 months, well, our hands are tied there. They need the TRV, they need the completion of the medical report, and it has to go through a consulate. However, when the person is a U.S. national, and there's no medical requirement, and as a result there's no TRV requirement also, being an American, we usually have a bit more latitude. The problem is, do we always want to give our clients the option of this latitude when we hear that the employee is adamant about entering through Sarnia, and he's going to be a management consultant, but he just can't seem to get his hand on that management consultant agreement? Do we really want to say, well, you can go through the Sarnia port of entry? I think at that point, that's when we have to basically use all our resolve with the client and encourage them. Really, it is in your best interest to spend the 2 weeks to get a counselor pre-approval, or perhaps route them through Dorval or Montreal, even though it makes no sense that they're just going across the border literally. But my paper analyzes the factors that a person has to examine before coming to a determination with his clients as to where to process, at the border or at the consulate. Now, the first factor is, does the applicant require a temporary resident visa? If they do, then of course you know that you have to go through a consular process. Now, one of the things that arises is that you get an employee saying, who's, let's say, a South African national, but I do have a visa, I really do, I should be able to apply at the border. And then you have to examine what type of visa they have. Oh, well, it so happens they have relatives in Canada and they got a multiple entry 1-year visa as a tourist. They have one of the V-coded visas. Well, a V-coded visa is not going to enable you to do a port of entry application for a work permit. In fact, in order to get to use a TRV, it has to be properly coded for the occupation that they will be undertaking in Canada. So a WX or a V visa will not facilitate a work permit application at the border. And after speaking with some port of entry officers at Pearson, they said that if they see a TRV that's even coded as a W1, which is worker, they will go into CAPES and they will read the remarks entered by the visa officer as the justification for issuance of that particular visa. So let's say Mr. Dutoit at Pretoria applied for a work permit with a previous employer, still has that valid W1 visa. That W1 is not going to be valid for the purpose of applying for a port of entry work permit for a new employer. It actually has to be consistent. So that's one of the first things you have to examine. Do they need a TRV? And if they do have a TRV, is it a TRV that could be used for a border application? Second factor that you want to examine is, does the applicant require completion of a medical report? Now, if an applicant is going to be in Canada for more than 6 months and have resided in a designated country for more than 6 months within the year preceding their arrival in Canada, then they're required to undergo a medical examination prior to entering Canada. Now, I don't know if people are aware, but ports of entry officers do have access to Immigration Health Service records. However, just for a number of practical reasons, you wouldn't really want an applicant to have to undergo a medical without a consular process prior to his arrival at the port of entry. Because first of all, the applicant has to get his hands on a medical form, and some designated medical practitioners are willing to issue a medical form to an applicant and help them complete it. But then you run into the problem of, what if they don't have a client ID number? If they've never applied for a Canadian immigration document, then what is the designated medical practitioner going to enter on the top right-hand corner so that Immigration Health Services can track it? And then, of course, third, it becomes very difficult to follow up with Immigration Health Services to confirm that, in fact, the medicals were received, that no further testing is required, and that the applicant has been approved for entry to Canada. So practically speaking, the only time that it would be advisable to send a person to a port of entry for a work permit application where a medical report is required is if the applicant has already previously applied for a Canadian immigration document, they were approved medically, and the results of the medical remain valid so that the immigration officer at the port of entry can access the records without problem. And that basically means that the medical had to have been completed within the year preceding their arrival in Canada. The other thing that we should take into consideration now as a result of IRPA and the provisions for misrepresentation in IRPA is that if the applicant suffers from a serious medical condition, you really must evaluate whether you would want to send this person to the port of entry. I know that previously, under the old Act, council would advise applicants sometimes who they were aware of suffering from a serious medical condition to go to the border, because at the border you don't have to complete an application form, and therefore you don't have to disclose the fact that, you know, you're being treated for cancer or something. And it was our understanding there was no positive duty to disclose this in the old Act. However, that's no longer true. Now, as a result of the strict rules for misrepresentation, a person who withholds material facts relating to a relevant matter that induces or could induce an error in the administration of the Act is liable for misrepresentation. So it puts practitioners in a very precarious position, because if you want to send somebody to the border, you have to tell them, you know, even if the officer doesn't ask you, you have a positive duty now to disclose the fact that you suffer from a serious medical condition. And what will that lead to? You don't know how that port of entry officer is going to deal with that. They may direct you for a medical report before you enter Canada, or they may just outright refuse your entry. So of course now it's advisable for any client who suffers from a serious medical condition to apply for the work permit at the consulate and then let the visa officer decide whether or not this condition warrants completion of a medical report. Now, the next category, or the next factor to examine is, does the application category permit port of entry processing? the immigration regulations are actually very generous in terms of the categories of application that permit port of entry processing and the ones that require consular approval. According to Regulation 198, the following persons may apply for a work permit at a port of entry: all nationals or permanent residents of the United States and residents of Greenland and Saint Pierre and Miquelon, the contiguous territories, and also persons who are exempt from obtaining a TRV and whose entry does not require HRDC confirmation. So that really includes a really large group of applicants. It includes entrepreneur applicants. It includes the C-12s. It includes the reciprocal agreements. Then, if you go further in the regulation, it says the following persons must apply for a work permit outside Canada: all persons who require a TRV, all persons whose entry requires HRDC confirmation, except nationals and permanent residents of the United States and residents of contiguous territories, and all persons who require a medical exam unless valid results are available at the time of entry, and as well international youth exchange program participants other than U.S. citizens. Now, although permissible, it's not advisable to submit an application for work permit under certain categories, such as C11, the entrepreneur, and I believe C10, significant benefit. Robin's already gone over the restrictive language in the Foreign Worker Manual, which relates to C10, where in 3 different places on the same page, they say that officers should be reluctant to issue a work permit without the assurance from HRDC that the impact on Canada's labor market is likely to be a neutral or positive. And officers should be particularly reluctant to issue C10. And then another few sentences down says, all practical efforts to obtain the HRDC confirmation should be made before C10 is applied. So, you know, as a practitioner, sending your client to the border to do a C10 in the face of 3 references to not being issued a C10 unless absolutely necessary is perhaps taking a bit of a risk. And with respect to C11, the Foreign Worker Manual states, it is expected that it would be a rare applicant who can satisfy an officer that their entry would provide a significant benefit. So in light of that, you really don't want to be sending your entrepreneur applicant to the border for assessment. And as a general rule, any application, regardless of category, that requires an officer to examine extensive documentation or requires an understanding of a technically complex issue with respect to the product involved or the services to be provided or the specialized industry, or where there are multiple companies involved in the transaction, should be processed at the Canadian Consulate. And everybody knows with these software worker contracts, I mean, sometimes you have to draw a flowchart diagram to figure out who's retained who's subcontracted who, and then who the final user is. So you don't want a port of entry officer to have to go through 5 different sets of contracts just to figure out who's retaining who, and then who's actually paying the income, but who's receiving the end benefit. And as my general rule of thumb is, if you can't figure out the rationale for the application in less than 10 minutes, don't send that application to the port of entry, because with the limited resources and the long lines that exist at all the ports of entry, the last thing you want to be doing is having a port of entry officer sit there and say, I can't believe this lawyer sent me this long, tedious application. What are they thinking? Because you're not getting off to a very good start right there. Now, the next issue that we should examine is a certificate of acceptance from the province of Quebec required? Now, we Ontario lawyers, we somehow overlook that, you know, a different set of rules apply, and when we have to figure out whether or not we can process at the border for people who are spending some time in Quebec, we actually have to think about the Quebec Ministry's requirements. Now, where a CAQ is required, the CAQ approval letter must be obtained as a prerequisite to the issuance of the work permit. Now, when is CAQ required? CAQ is required for all employment activities destined to the province of Quebec, where the duration in Quebec will be for more than 5 days, and in the following categories. Applications that require HRDC confirmation and deemed confirmations, which are the software workers, the Canada Research Chairs, and Stephen's here now, and Stephen's favorites, the exotic dancers. And also CAQ is required for study permits. Now, although the Ministère des Relations avec Citoyennes et de l'Immigration processes the CAQs relatively quickly, you still wind up having to lose some business days to obtain the CAQs. So in light of the fact that you're already going to be spending 3 to 5 business days waiting for a CAQ, it may be then in your best interest to go ahead and file at the consulate. You can go ahead and file at a Canadian consulate with all the documents minus the CAQ, and as soon as the CAQ is issued by the Quebec government, just fax the CAQ approval letter over to the consulate, and I find that the consulate expedites the issues of work permit approval letters where a CAQ has already been received. You don't usually have to wait the 2 weeks standard processing time if they already have the CAQ approval on file. And this is something that you really have to be mindful of, not where the HRDC confirmation is involved, because an HRDC office in Montreal will not issue you the confirmation letter unless they already have the CAQ, but it is extremely valid to in the software worker category, because you would otherwise think, oh, well, software worker going to Quebec, he can just show up and do it at port of entry because he's a U.S. citizen. You have to get that CAQ first. So might as well just file at the consulate, because at the end of the day, you're not getting that applicant in tomorrow. So if you get them in on a Thursday or as opposed to a Friday, I think it's in your client's best interest just to wait and get the consulate pre-approval. And then the next factor to consider, which most people don't often consider, is processing at the consulate even permissible? Where a TRV is not required, consulates do not issue documentation confirming that an applicant is a business visitor and, in fact, work permit exempt. And now with the defined categories for a business visitor, the consulates are even more adverse to even handling these cases, which does create a slight disadvantage to some of our clients, because some of these business visitor categories are now very complicated in terms of documentation required and poring over whether or not they meet the definition of that exemption. So basically, you're put in a position where you send an applicant to a port of entry and you just hope that the officer at the port of entry is familiar with the exemption category and can readily understand the documentation. And we just, no offense to Paul, I'm sure Paul trains his staff extremely well, but in the past I've had to send faxes to ports of entry officers confirming that in fact there is a spousal work permit policy 3 years after the spousal work policy came into force. And I actually had to just recently in July faxed a port of entry stating confirmation that the software worker category did survive IRPA. So, it's advantageous to be able to process business visitors swiftly at the port of entry, but given the limited resources of the consulates, unfortunately, we can't get any pre-approvals for business visitors. And then, of course, the factor that everybody has to address for a port of entry application is, when does the employee need to enter Canada? And you ask a client the first day, when does your employee have to enter Canada? He'll say tomorrow. You tell them about how many tears he'll shed if he goes through Sarnia with a management consultant application. And then suddenly it's like, well, maybe we can wait 5 days. And then you find out through the applicant that he fears immigration officers more than he fears anything else, and he doesn't want to answer any questions if at all possible. And so then you think, okay, well, fine, we're going to pursue the consulate, and he's just going to have to explain to their client, their end users in Toronto, that tomorrow means 10 days from now. So if a person has 2 to 3 weeks prior to their anticipated entry date, of course, pursue the counselor pre-approval whenever possible. Get a counselor pre-approval. But not always do we have the luxury to wait 2 to 3 weeks. What some people aren't aware is that many consulates in the United States, as well as many of the embassies throughout the world, do accept walk-in applications by applicants. And if your employee resides near a consulate or can readily travel to a consulate, then you should really consider sending that employee on a walk-in basis. Check with the consulate beforehand, of course, that they do take in walk-ins. And generally speaking, walk-in applications can be adjudicated in 1 to 5 business days. And if you shop around between the consulates, you can generally find consulates that are very facilitative on this. And then that way, you really do benefit from the fact that you have the expedited time, and it may well be worth the extra expense of having to fly somebody to a nearby consulate or embassy, as the case may be. Now, in my opinion, you should only submit an application at the port of entry when time does not permit obtaining a pre-approval from a consulate, even when the application is very straightforward, like let's say a NAFTA engineer. It might be very fast for us and the end user, but it's not a very expedient process for the applicant, him or herself, because, of course, if an applicant presents a pre-approval letter to a port of entry officer, all that port of entry officer has to do is enter the approval number, and then the work permit document is generated very fast. Usually within 10 minutes, the employee is in and out of there. But if the employee has to stand in line and then get to the officer, then have to rationalize the purposes of entry to Canada, have the port of entry officer pour through all the documentation, then have the port of entry officer have to enter every single field in the computer system, that employee is going to be standing there for maybe up to half an hour or 45 minutes, as the case may be, and he walks out of there with a pretty bad feeling, thinking, wow, that really took a lot longer than I thought it ever would. So you should make your clients aware of this fact. Very few clients know that there's a half an hour difference in what they'll have to go through when they do get to the port of entry, and in fact that they're going to have to justify the nature of their employment, their background, their duties in Canada, and why it is that they can't, that it wasn't reasonable for them to perhaps find somebody else at the local Canadian branch to undertake these activities. Now, the next factor that we have to look at is, does the applicant have a criminal conviction? You must ask your applicants, do you have any criminal convictions? And you should actually give them examples of what a criminal conviction is, because I have yet to find an American citizen who acknowledges that a DUI is a criminal offense and not just a traffic violation. So once you find out whether or not a person has a criminal offense, you have to also go back to the misrepresentation provisions, that previously people could go to the port of entry with a criminal conviction, and they would try their luck. That if the officer didn't notice anything in CPIC, and if they didn't ask the question, then they could get through without having to get formally a minister's permit to enter Canada. Well, no longer. Now that you have the positive duty to disclose any material fact that could induce an error in the administration of the Act, that applicant cannot state, well, the officer didn't ask me if I had any DUIs. He has that duty to disclose. And in fact, because of the enhanced information on CPIC, the Canadian Police Information Computer System, officers are able to view all U.S. state police records and the FBI information. I'm advised that they're not yet able to access Interpol records, but they certainly can send a communique to the appropriate office, who can then check up on Interpol if they want. But sometimes we don't have the luxury of saying, well, you have a criminal conviction, we don't want to apply for your temporary resident permit at the border, we want to apply for a consular pre-approval. if you have to apply for a TRP at the port of entry, make sure that you're well documented. You just can't rely on the fact that the applicant stated he had 1 DUI in 1998 in Wisconsin. Make sure that the applicant has the documents relating to not only the conviction, but confirmation of the disposition of the offense and that any sentence imposed has been completed. Now, although the CPIC system has details of offenses and convictions, they don't always have the confirmation of the disposition of the offense or confirmation that the sentence has been completed, because it's up to each jurisdiction in the United States to upload that secondary information to their national records, which then get transferred to CPIC. So whenever possible, make sure you have the state police certificates, sheriff reports, and county court dockets that show the disposition and completion of the offense. And usually you can get county court dockets relatively quickly, and usually a day in most jurisdictions, or within a few days. Now, it's also advisable to provide character references for the applicant, because after all, you have to provide the port of entry officer as much documentation as possible. And on a TRP for a criminal inadmissibility, I really don't believe there's anything such as too much documentation. Now, where an applicant states or is of the belief that he or she is rehabilitated or deemed rehabilitated under the new provisions, then of course the onus is on the applicant to provide proof that the required time has elapsed since the completion of the imposed sentence, not just since the date of the conviction. And now if you have multiple offenses, or if your client has multiple offenses and you want to send them to the border, if you have multiple offenses, you're not practicing, hopefully. But if your client has multiple offenses and you have to send them to the border, if I were you, I would prepare them for the strong likelihood of refusal. And that's all I'd really tell a client. I wouldn't want to encourage them to think that, oh, this is a doable option, because you just don't want to put them in that position. And at the end of the day, it's our responsibility to just be as frank as possible. If you have 3 DUIs in the last 5 years, along with a theft or an armed robbery, what port of entry officer should be letting you in?
That's right. Paul's got so much to comment on already.
I'm almost
She's
just...
stolen all my thunder. I'm just going to be sitting here being a pretty face.
Oh, but he has a list of questions that I know we all want him to address. Now, and also, one last point on the criminality. The more criminal issues out there on the applicant's background, the more justification you have to provide a port of entry officer as to why you couldn't obtain a consulate pre-approval. Now, through which port of entry will the employee be entering? That is usually the key question, isn't it? And that usually is the toss-up between, should we actually pursue the port of entry application, or should we delay the entry altogether and get a consular pre-approval? Now, if the application is really clear and straightforward, then maybe it doesn't matter as much what port of entry, like a spousal policy application. Well, now it's an exemption in the regulations. But anything that requires a subjective conclusion on specialized or technical knowledge or significant benefit or management consulting duties, port of entry that you select is crucial. Going back to the specialized knowledge issue that Howard and Robin were discussing, just to highlight, like in GATS, which unfortunately isn't reproduced in the new Act and regulations as clearly as it is in the GATS manual, it actually comes out and says right here, under specialized knowledge, that to qualify as a specialist, you must have advanced or specialized knowledge that is not readily available in Canada regarding the company's product, service, research, equipment, techniques, or management. You would usually be in a position that is critical to the well-being of the enterprise. Now, this reference to not readily available in Canada is not in NAFTA. In fact, NAFTA actually states that you don't have to analyze labor market. So you want to find a port of entry where the culture is really applying the NAFTA test for the new C12 as opposed to this GATS test, which they could just as easily point to and say, no, 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 this is now the C12. And it is crucial that we as practitioners figure out the culture of the respective ports of entry, and also the categories of applications that certain ports of entries are more generous and more facilitative in interpreting than some of the other categories. For instance, we know that Calgary would probably have a more restrictive interpretation of specialized knowledge, more in line with GATS than with, let's say, Toronto. And I'm not even going to comment on Windsor or Sarnia. We're all familiar with it. Now,
I guess you have.
well, not in so many words. But there's something that I don't think that practitioners encourage their clients to do enough, which I just think is a wonderful option. It's the best of both worlds. It's getting a pre-adjudication of a submission, and you can actually rely on the pre-adjudication unless something arises between the time you fax the port of entry, the application package, and the time that the applicant actually enters. What I'm referring to is the pre-adjudication process that exists at Dorval Airport. Now, you can fax your application package for a work permit to Dorval Airport the morning of or the day before the applicant is scheduled to enter. And you just state your contact details on the front of the fax, and they will call you back, usually the same business day, and give you a determination of your application. They may ask for further documents, or they may say, yeah, this is fine. And then you provide the officer with the applicant's entry details, and then they anticipate his or her arrival, and as long as all the other admissibility issues are satisfied, that applicant gets a work permit. And I think these officers are wonderful human beings. I actually call them and I say, well, I have somebody who lives in Minneapolis. His end destination is Regina. Do you mind that I fly him to Regina via Montreal? And they go, oh, no, not a problem. I said, but it's going to weigh on your resources. They go, no, that's fine. I thought, wow, this is wonderful. And don't worry, you don't have to do anything in French. You can do everything in English, and they're just as fine. And it really is the best of both world option. And so then I called people at Pearson, and I said, well, you know, Dorval does this. Would you consider doing this? No. Do you have any intention of doing this anytime in the near future? No. Okay. And I wasn't even going to call Regina and ask them because, you know, Regina gets about 4 work permits a month, and they're just so eager to see the applicants and talk to them. I actually had one applicant arrive in Regina through one of their 3 international flights, which was like Minnesota, North Dakota, and some other state. And they kept the applicant talking to them for like 40 minutes, issued the work permit, but they were just so happy to have an applicant there adjudicated. But they're nice people in Regina, yeah.
Lonely.
And then just the final...
Unwanted and unloved.
And just the final few things you want to look at is the duration of entry. Chances are you get a longer approval through a consulate than a port of entry, only because port of entry, you know, the justification for issuing a 2 or 3 year work permit, they have to be a lot more certain about the rationale for the employment. How strong is the application? If it's not something you'd file at a consulate, don't try it at the border. Don't have this attitude of, you know, we just need to get the person to the border. The issue is not getting the person to the border. The issue is getting them the work permit. So haste makes waste. And it's better to file a less than perfect application at a consulate because the consulate can always send you a fax saying we need X, Y, and Z documentation. But a port of entry officer isn't going to be that patient. And then finally, which is extremely important, is the applicant articulate? I don't care how easy your application is. If your applicant is unable to express his ideas and unable to convey his expertise to a port of entry officer, even if it's an NAFTA engineer application, do not send that applicant to the port of entry for processing. He'll be upset that he'll have to speak to his skills. He'll be very nervous. You'll get a hysterical call from him 5 times before he even gets to the port of entry. And at the end of the day, it's better that you just do consular processing. So now I'm going to turn it over to Paul, and Paul already has a list of questions that he's to address, as well as all his other comments for how we can process better for our clients.
She said it all. I've got absolutely nothing to say that anybody would want to listen to after that, because I can't say it as well as Yusra just did. But perhaps maybe I should state the obvious. The world did change for immigration processing on September the 11th. Everybody, regardless of the category they fall into, is being looked at much more closely than they were being looked at prior to September the 11th. Most particularly refugee claimants. This forum today is not about refugee claimants, but what used to take 3 hours is now taking 5 hours. The safe third country agreement that's on the horizon has increased the number of claims we're seeing at our land borders. This is a big drain on our resources, and it's taking officers' focus from some of the more facilitative aspects of the job and redirecting them towards the more enforcement-related activities, including the examination of refugee claimants. So the bottom line is there's just the same number of people doing more work with the focus of that work on enforcement activities and less for facilitation activities. As Yusra has just most ably advised you, don't send complicated cases to ports of entry. They don't have the time to deal with them. There's some serious resourcing issues at some ports of entry. Obviously not in Regina, and obviously not at Dorval. And clearly Treasury Board has given Quebec region and the Prairie region far too much money. But when we look at just some simple volumes, and if I knew Yusra was going to make reference to some other areas of the country, I would have done sort of a comparison. But just in Ontario region alone, from the fiscal year 99-2000 to last fiscal year, the number of work permits has jumped from 61,000 to 65,000. There's basically a 50-50 split between visa post processing and port of entry approvals. So of that 65,000, we're probably looking at about 33,000 that were done from scratch at a port of entry. Pearson Airport alone, out of that 65,000, did 42,000 work permits in the last fiscal year. They also did 100,000 immigrant landings and approximately 5,500 refugee claimants. I mention the number about immigrant landings because the time that's expended on an immigrant landing has doubled since ARPA. With the permanent resident document, we now have to muck about with a special form, with a special camera in order to get a special picture and a digital signature. That's doubled the amount of time. So that takes away, with no additional resources, so that takes away the amount of time that's available for facilitative processing in other areas such as work permits. Yusra has made reference to the wonderful and talented people at Dorval, who are destined clearly for sainthood. And here we are in Ontario going straight to hell. And, you know, we're almost in Saddam's back pocket. However, what we're looking at doing, and I don't know whether, I have no idea what Pierre spoke about this morning. I have a rough idea, but we have met, Pierre and myself have met with the management in the Niagara region. We did that in mid-January, and we're considering something similar to the process that exists at Dorval. Dorval is rather special in that because of the way they receive their flights, because of the way the airlines schedule their flights. They have a huge amount of time in the morning that no one flies in there, and they don't have any business, and they have to justify all of these resources that they clearly have. We don't have that luxury in Ontario at any of our ports of entry, including Pearson. We deal with passengers every day, all day, 24 hours a day at most of our land borders. Pearson is lucky to shut down from 2 in the morning to 6 in the morning. That's basically when you won't find any immigration officers there. The likelihood of a process similar to Dorval's being instituted at Pearson in that form is not likely at this stage, but what we're going to do is try and pilot something, probably not until after the war and after the summer, and I don't know what's worse, the war or the summer. But we'll be looking at doing that probably in September at Niagara. We have a draft proposal that we will be presenting to the Port of Entry subgroup, of which David Garson is he president? So what do you call David Garson in the Port of Entry subgroup? President?
Chair.
Chair, sorry. So at our next meeting, which should be scheduled reasonably soon, we'll be going to the Port of Entry subgroup and saying, this is our proposal. We're putting this out to you for your input and feedback. Please get back to us on this. I doubt if it'll be anything identical to the Dorval process, but I think it'll fall someplace in between the just showing up at a port of entry and visa processing. There'll be a balance there. One thing you want for your clients is that their border crossing be trouble-free. And there's usually 4 areas of difficulty that lead to troublesome border crossings. And in order to avoid the troublesome crossings, ensure that your foreign worker, that your client has adequate identification. This is usually not an issue for people flying into Pearson, often international flight. It's quite frequently an issue at the land borders, particularly since September 11th. The likelihood of a port of entry officer asking for something other than a tattered driver's license or social security card is fairly high. So my advice to you would be to ensure that even though your American clients don't need a passport, tell them to get one if they want to avoid aggravation on that count. Ensure that the foreign worker has adequate documentation to support the purpose of their entry. This is usually not a big consideration when lawyers are preparing submissions for their clients to present. Usually they hit all the points, but this frequently can be an area of difficulty. Don't skimp on your documentation, but don't go overboard either. Ensure that the documentation that you do provide is clear and concise. The resources at the ports of entry are under pressures. They don't have the time to read War and Peace. So don't give them War and Peace. Give them the Coles Notes version of War and Peace. Ensure that your client is aware that there's a cost recovery fee for a work permit. My background is at Pearson, and you have no idea how often people will walk off a plane, you told them they need a work permit, with or without a submission from one of you, and they didn't know they had to pay the fee for the work permit. So ensure, and I'm sure most of you do, but ensure that they are aware that there is a fee for the work permit. In terms of business visitors, the business visitor category is new with NAFTA, or excuse me, new with IRPA. It's existed in NAFTA for quite a while. When your clients, your business visitor clients, are coming to a port of entry, if at all possible, ensure that they have some documentation to rationalize how they meet the business visitor definition. And of course, that will be specific to each individual case. I have been asked in the past about commercial speakers. There's been a change in IRPA as relates to commercial speakers. These individuals prior to IRPA required work permits. They can now be allowed in for a period not to exceed 5 days. And ensure in any documentation that they'd be presenting at the port of entry that is really clear that they're not going to be here for more than the 5 days. After-sales service is one of the most troublesome business visitor activities. Ensure that your clients, before they sign a sales agreement, have clear wording in the sales agreement that provides for the after-sales activity. So that would be proactive right up front. It's a mandatory requirement that the foreign worker who's going to be delivering the after-sales service have a copy of a sales agreement or a purchase order or a warranty agreement to support the purpose of their entry. And there should be clear wording in that agreement that you've prepared before it was signed to support that purpose of entry. I realize that some of these sales agreements are extremely lengthy, can go over 100 pages at times. If that is the case, as long as the person has the relevant pages, they should encounter no difficulty. In your documentation for after-sales service, clients, ensure that there's a rationale to demonstrate that the worker possesses specialized knowledge that's essential to the seller's obligation. That's a requirement. Be sure you cover that point. With regards to intercompany transferees, and that includes intracompany trainers and trainees, Try and keep your submissions down to 2 pages and stick to the elements. Pearson called me once about an intra-company trainee situation. The submission was 75 pages of small print. Well, I wasn't going to read the 75 pages for Pearson. But I told Pearson, if you've got the time, you go find the loophole, because someone is trying to pull the wool over your eyes. And that's the frame of mind that an immigration officer will have when you provide a really lengthy submission, even if you're not trying to pull the wool over somebody's eyes. It gets somebody really suspicious right off the bat. And of course, who's going to pay the price? It's going to be your client sitting there while the port of entry officer is trying to sort through the submission. For intercompany transferees, it's really helpful if you have kind of a summary page where you hit the highlights. And the port of entry officer, if they're really stressed, if it's Pearson Airport, if it's Sunday night, if there's a huge lineup of people, they might only actually look at that summary, especially if you have a good track record with the officers. They know your letterhead, they know your work from past practices, they'll take a chance on you. Quite frequently, in terms of intercompany transferees, the submissions do not clearly state how the foreign worker meets the employment history criteria, because there are requirements for that the foreign worker have been employed by in the foreign jurisdiction for a certain period of time. Make sure that's clear in the submission. State clearly how the foreign and the Canadian company meet the qualifying relationship, be that parent, subsidiary, or otherwise. Provide some information to satisfy the port of entry officer that both companies in Canada and in the foreign jurisdiction are currently doing business and will be expected to do so while the foreign worker is here in Canada. One of the visa posts, not a port of entry, but one of the visa posts had a submission for 3 persons who were golf pros. And it was a golf pro company, and only 3 people in the golf pro company, and they were all coming to Canada to do their golf pro work in a province that was not Ontario. So while those 3 people were going to be here, they obviously weren't offering their service in the foreign jurisdiction. So the application was refused. We're going to be going to a coffee break. I have 1 minute left. In terms of managers in intercompany transferees, ensure you document who the manager is managing. In other words, other managers or supervisors, or groups of persons at a professional level. And if it's a functional manager, I suggest you don't put that application through to a port of entry, but if you do, ensure that you can satisfy the port of entry officer that the person is managing the function and not doing the function. And we will be going on that note to break.
Thank you. A fast question.
Sorry, just a quick question. If an applicant arrives at the border and they've got all their paperwork together, no misrepresentations, no criminal record, does the border official or must the border official allow that person entry? Or can the border official just discretionarily say, I don't want you in anyway?
Well, they certainly can't say we don't want you in anyway. If the border officer is denying somebody entry, they have to have good reason under the Act or the regulations to say, no, I'm not letting you in. And those reasons are enumerated in the legislation.
If they can't find a reason, that person has to be let in.
I don't see any other option.
Can I ask a quick question? And you know the question I'm going to ask. It has to do with implied status. In the Foreign Worker Manual, there's a reference to people having implied status now where they filed an extension at CPC prior to the expiry of their existing work permit document. And from the chart on page 46 of the Foreign Worker Manual, it says, do they need a work permit? And there's all these business visitor categories, and the last little bullet point says implied status. So that almost suggests that somebody who's on implied status in Canada can actually leave Canada and then present themselves for readmission back to Canada. Do they still have implied status?
Well, you made reference to a chart. My friend Nadine could give you an earful about what I think of charts. I have definite opinions about charts. I don't like them. They tend to be too simplistic and tend to mislead people at times. If somebody leaves Canada, if somebody's been here on a work permit, they've applied for an extension of their work permit, and nothing has changed with regards to the circumstances surrounding the issuance of that work permit, except for the expiry date, they're allowed to remain under what is called implied status and continue working at their job, and it's 186 something bracket, and I don't recall what the bracket is, T or V or something. What happens is when a person leaves, that vanishes. That implied status vanishes. And it's a brand new ball game when the person turns around, comes back, and attempts to enter Canada. So the person is not considered to have implied status if they leave and they come back. They're considered to have implied status only until such time as a decision is made on the issuance of a work permit and the person remains in Canada. And knowing that I would have that question this morning, I did touch base with NHQ on that late yesterday.
They can, however, be readmitted as a visitor, for instance, until the work permit is continued.
As long as it's not their intention to work until a work permit is issued to them.
Well,
But
The reg's prohibited. It says you have to remain in Canada during the process.
yeah,
No, if they leave Canada and then re-enter, say.
No implied status.
No implied status, but they could be allowed to re-enter as a visitor until processing of.
well, wait a moment now. If you leave Canada, that terminates your application at the Case Processing Center.
in theory it should.
If it does, then your client re-enters Canada. In order to avoid a misrepresentation with respect to the administration of the Act, you should be advising Vegreville that there's a new application being made, that application should be terminated. And that if he works on the work permit issued from Vegreville after departure, you probably have a contravention of the Act.
I would think
Right?
I would think the most prudent thing would be for you to provide your client with the same documentation that you have already sent to Vegreville, so that he can present that at the port of entry.
Unless he can't get a work permit at the port of entry.
Then send him to a visa post.
That's a very important point. It's personal liability for you. Well, let's have coffee. Thank you. Thank you. Thank you.